Sir, it is 6 o'clock. Can we start the session, sir?
Yes.
Good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Vivek Subba Reddy, Senior Advocate, High Court of Karnataka. Sir, we are elated to have you with us today. Welcome to the webinar.
Thank you.
With immense pleasure, now I would like to introduce our today's speaker. Mr. Vivek Subba Reddy is the son of former 8-term president of Advocates Association Bengaluru and former MLA from Basavanagudi constituency, Shri Subba Reddy. He is an alumni of University Law College, Bengaluru. Mr. Vivek has extensive practice on civil laws, trademarks, copyrights, patent laws, constitutional law, and many more branches of law. He has argued several cases before the Honorable High Court of Karnataka and Supreme Court of India. He is designated as a senior advocate by the Honorable High Court of Karnataka. Apart from advocacy, Mr. Vivek is a social activist and is the founder of Advocates for Green Earth Forum. He is also the pioneer of Clean Nandi Hills campaign. He also took initiative of starting Shall Vote campaign to increase the urban voting percentage. He has argued several public interest litigations on environmental issues, KPSC scam, slum dwellers Hakkupatra, etc. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you, Trivikramji, and thank you for your introduction. And I also thank the Secretary of the Association, Shri Gangadhar, who is there with us. Friends, for a moment, we have to thank the Advocates Association. It is one of the largest and premier associations in this entire Asia. I don't think there is any United Advocates Association till today with about 20,000 members and in excess of 20,000 members. That shows the great strength, unity amongst the advocate fraternity in this institution. And throughout India, wherever we go, our association is regarded as one of the most premier bodies. It is an institution that has in the past stood as a guardian, past and the present. It has stood as a guardian for all and many excesses that have taken place. We really thank the president of the association and the office bearers for having organized these webinars successively in order to share our little experiences with friends from the advocate community. Friends, the topic that Trivikram gave me today is very interesting. This is one of the most, perhaps the most important facets of our constitution. How does our constitution, under what principles does our constitution validate, under what principles in our constitution can we challenge the laws of the legislature? I think this is one of the niche areas which had not been covered till date, so Trivikram asked me to address on this issue. It is a big universe itself, the number of case law that is there, the principles that are there, and it is very tricky and complicated to segregate issues here, particularly the case law. But one aspect is the principles are very fundamental. Lord Denning used to say very beautifully, he used to say, however complicated the law is, or however vast the data is in law, ultimately the points on which you canvass are very precise and very brief. For example, you may say, so our clients will come and ask us generally, sir, you have so much of books, you have so much of files, how do you read it? Well, if we look at, we all know as practitioners that ultimately what is important in law is a few points which tilt the case. And getting hold of those points is essentially what advocacy is. In the present context of our subject, the Constitution is a vast, one of the largest constitutions in the world. But where is it written in our Constitution that you can challenge a law with respect to a particular article? Has the Constitution specified that you can challenge the law with reference to a particular article? For that, we have to have a brief analysis of how our Constitution actually evolved. If you look at the American Constitution, there is no word saying an act passed by a legislature can be constitutionally voided by the courts. There is no provision at all. Ultimately, it fell upon Justice Marshall in Marbury versus Madison in early parts of the 19th century, 1810, 1812, for him to say that, look here, whatever is beyond the framework of the Constitution, a law passed contrary to the Constitution, is illegal. A very similar analogy to this is what we see as the ultra vires concept in administrative law. We have a statute. Administrative law principles stipulate that if there is a statute and an administrative act is contrary to the statute, then we draw in the ultra vires concept and say that the act is ultra vires. The administrative order should be voided. In a similar fashion, we have a constitutional framework. The Constitution sets out the framework, and within that constitutional framework, we draw in this ultra vires concept. If a statute is framed contrary to the constitutional framework, then it is void. But who is to decide this? In all constitutions of the world, it is for the judiciary to decide it. When our fathers of the Constitution, our framers of the Constitution actually brought out this Constitution, they entrusted this power under Article 32 and Article 226 upon the judiciary in India, the Supreme Court and the High Courts, which are the superior courts, to decide the constitutional validity of the laws. Now, Hamilton says, very beautiful instance, very beautifully he narrates, Hamilton, who was one of the framers of the American Constitution. Hamilton says that you may have bodies of laws. You may have so many, you may have a written constitution. You may have several bodies within the written constitution. You may set them up in various hierarchies. You may set them up at various levels, saying this is the highest organ in the executive. This is the highest organ in the legislature. This is the highest organ in the judiciary. You can do that. But ultimately, what is essential is that when legislature passes a law, the law passed by the legislature there has to be an umpire or an institution to decide that law, whether that law is valid. Then only will the sanctity of the Constitution be maintained. For this, Hamilton said, we need an institution like the judiciary, which is very, very independent. Friends, coming to this point as to what are the grounds under which laws can be challenged under our Constitution. It is actually very simple, these principles. The first is, there are about 5 or 6 principles, and these principles are the only grounds on which we can challenge a law. The first principle is Article 13. Article 13 says, all pre-constitutional laws before the Constitution came into force are void if they breach the Constitution after the Constitution has come into force, if they breach Part 3. Article 13 is one of the preliminary articles of Part 3, which is the chapter on fundamental rights. And fundamental rights itself are the rights and guarantees given by the constitutional framers under our Constitution to the people of India in order that they live a life of freedom, a life of liberty, a life of equality. All these human freedoms, which are very essential for sustaining an individual, for sustaining a human being, and to ensure that that human being achieves the greatest growth possible in his life and uses all opportunities of life. This is what is embedded in the fundamental rights section. There are still more angles to this fundamental right. We'll come to it later. But one of the grounds under which it is challenged is the Constitution says, the Constitution of India very specifically says, unlike the American Constitution, that you cannot pass a law which violates the Part 3 fundamental rights. This is the purport and meaning of Article 30. It has two parts. Pre-constitutional laws are voided upon the coming into force of the Constitution. Post-constitutional laws, no law can be passed under 13(2), and such a law, if it is passed, if it breaches Part 3, the fundamental rights, then it is void. This is number one. The second aspect is how a law can become unconstitutional. One manner is if it breaches Part 3. The second manner is when a legislature passes a law, the legislature usually is given the function of passing the laws under Article 245 to 254 of the Constitution of India. And along with that, each legislature, the state legislature passes laws under Schedule 7, List 2. The union legislature passes laws under List 1, Schedule 7. And both the state and the union have been given overlapping subjects under List 3, Schedule 7. Now, if suppose a legislature, this is called abdication of the legislature or self-effacement of a legislature. The leading case is Queen versus Burra on this subject. I will come into it in more detail. But the principle on which the law can be challenged, laws passed by legislatures can be challenged is that if there is abdication by the legislature instead of passing the law, the legislature says the government will look into the various formalities and fill up the vacuum in the law. The legislature basically passes a very sketchy law, a skeleton law, and says it abandons or abdicates its powers to the legislature, and it says to the executive, and it tells the executive, you pass the laws, or you look into the material that has to be brought into the act. Then the courts will hold that this is playing foul with the Constitution. This is a fraud on the Constitution, because powers are not given to the executive. Powers are actually entrusted. It is a trust which is placed by the Constitution upon the legislature only. So the legislature cannot abdicate and run away from that responsibility. This is the second ground. So we have two grounds here. One is Article 13, which is in the context of Part 3, which says that no law can violate the fundamental right. Second is a legislature cannot abdicate its responsibility, cannot betray its trust and give it up to the executive. It has to legislate. The third ground is the overlapping entries. Suppose I, as a state of Karnataka, the legislature of Karnataka, passes laws on a union subject. These three areas or fields of legislation are prescribed under Schedule 7 of the Constitution. As List 1 is union, List 2 is state, List 3 is overlapping between states and union. Suppose as the state of Karnataka, the Karnataka legislature says, while legislating on land, the Karnataka legislature says, I will also legislate on mining. Then it is intruding into the central subject. That's when they say that the law becomes void due to lack of jurisdiction. So we have three grounds, friends. The fourth ground is, the first is 13, the second is abdication, the third is no legislative jurisdiction because you have jumped into some other entry. The fourth ground is repugnancy, which essentially is brought out in Article 255 or 254 of the Constitution. When the state law is repugnant to the central law and both of them are entitled to make a law on the same subject. That is when under List 3 repugnancy arises. Under List 3 Schedule 7, both center and state can make laws on various subjects enumerated there. While it is making those laws, central government has made a law, the state government also makes a law, but both are in conflict with each other. Then the test of repugnancy is applied, and under the doctrine of occupied field, whatever area or ground the center occupies, that area attains supremacy, and that is the law. The state law will have to yield to the central law. So therefore, these are the four principles, friends, on which the laws of India passed by legislatures can be challenged. These would also include the regulations and rules made by the state under subordinate legislation. There is a fifth area, which is very interesting. There are various provisions in the Constitution which declare how laws must be made, or which lay out some basic criteria for the law. For example, under the 1993 amendment to the Constitution, the Panchayat Raj system and the municipal corporation local body system was expanded throughout India. And while it was expanded throughout India, at that instance, the Constitution said that there must be a certain manner in which seats have to be distributed among scheduled castes and scheduled tribes. It also said that there has to be rotation. It laid out various criteria. When the Constitution has laid out this criteria, no state law like the Karnataka State Panchayat Raj Act or Karnataka State Municipal Corporation Act can violate those basic principles of the Constitution because of the paramountcy of the Constitution, and Constitution being the foremost document of the nation. So If we look at these 5 areas, for example, there are other sections like section 303, which says how laws have to be made regulating interstate commerce, how laws on taxation have to be made. So there are various individual sections, articles of the Constitution, which describe or lay down the parameters on which a law is to be made. So therefore, friends, basically, we have to just recapitulate the 5 grounds on which laws can be challenged. There are virtually no other grounds on which the constitutionality of laws can be tested. Of course, there are some other technical issues, such as how the law is passed, whether the law has been taken by a majority of the legislature, whether it has received the assent of the governor. These we can put away as technical issues. So to recapitulate these 5 important principal points. First of all, Article 13, which says no law in violation of fundamental rights. Second is, legislature cannot abandon or abdicate its power to legislate and give that power to the executive. Then the law is illegal, it is constitutionally void. Third is a case where the state jumps into the central list or the center jumps into the state list and the law is void due to lack of jurisdiction with respect to the entry to make the law. And fourth is repugnancy, where center and state are sitting in list 3, both make laws, then the center law must supersede the state law. And lastly, the constitutional ultra vires of laws. That is, the Constitution prescribes a framework as to how laws must be made with respect to municipalities, with respect to various other issues, other constitutional provisions. So these are the 5 broad parameters under which the laws are to be challenged. This is, for better reference, this is available in D.D. Basu's latest edition under Article 13. I will give you the page number also if I can as a footnote to this short presentation. And there it is specifically, these aspects are specifically enumerated. Friends, now, what is Article 13? In order to broadly focus on the Part 3 fundamental rights. Article 13, 1 and B are, they enumerate the fundamental rights under the Constitution. What Article 13 stipulates is that all pre-constitutional laws, to give you an example, for example, Article 13(1) says, all pre-constitutional laws which violate fundamental rights are void. An instance of this is the instantaneous triple talaq ban, which was declared unconstitutional by the Supreme Court. There was no provision which said instantaneous triple talaq should be incorporated as a principle of law in the personal law of Muslims. But still, the Shariat Act of 1920s stipulated that whatever were the decisions of the Privy Council till then, under Section 3, under 3 of the Shariat Act, that would be the personal law for Muslims from that date. So there was in existence a body of case law declared by the Privy Council, which formed the basis for the personal law of Muslims in India. And when the Constitution came into force, much later, perhaps 70 years later, the question of instantaneous triple talaq being valid or not valid, and whether it could pass the constitutional muster or whether it could pass the constitutional test as a law, that issue came into question. At that point of time, Justice Rohinton Nariman, who delivered this judgment, said, instantaneous triple talaq is manifestly arbitrary under Article 14. Therefore, it cannot be sustained as a law. So here we have that instantaneous triple talaq is violative of Article 14. Therefore, the law was declared to be void. What was declared to be void was not a regular talaq, but an instantaneous triple talaq. So therefore, the Supreme Court brought in Article 14. It said we are going to test this law as against Article 14. And in order to test that law, it used the concept of manifest arbitrariness, which is rarely used while testing a law. The normal Article 14 tests are reasonable classification and whether it has nexus. But the Supreme Court went ahead and said even manifest arbitrariness could be a ground to test the law. In a similar manner, I already told you about Marbury versus Madison, which said that though there is no statement which says that a law can be void in American Constitution, still we have to void those laws if they are beyond the Constitution. So therefore, friends, the fundamental premise of Article 14, why was Article 13 brought in? What was the reason for Article 13? Because the framers knew, and in any country, in any constitution, there are protections to fundamental rights. The constitution is always under a threat of some injury or threat of some assault from some majority. So therefore, what they do under such circumstances, this is a scenario that exists. Perhaps, this is a scenario for which the protections are given for throughout the life of the constitution. That is why they establish an independent organization and set up a judiciary and say that we will pass laws, but under the doctrine of separation of powers, it is a judiciary that will decide, that will interpret these laws, that will say whether these laws are void, or that will say whether these laws are not void. So this is the manner in which the law is decided. One interesting twist in this Article 13 concept is, suppose this is the doctrine of eclipse which keeps coming again and again, and which is a matter of raging debate before the Supreme Court. The problem is whenever a law is declared void, a post-constitutional law or a pre-constitutional law is declared void, one issue that comes up before the courts are, the high courts and the Supreme Court are, should we declare this law to be void from the very day the act came into force, or should we declare this law to be void from the date we declare give the declaration in judgment? There is a lot of debate on this. Many judges have said that when 13(a)(b) says, 13(2) says that all laws are void, you have to declare it to be void. There can be no remnant or residual unconstitutionality, even though events have passed by. But Supreme Court is alive to one fact. The highest court of this nation is alive to one fact. Suppose they say triple talaq is retrospectively invalid, then all the settled relations between people, those who have divorced and gotten married, and those who have been put into destitution, everything is unsettled for the past 70 years. Therefore, in such circumstances, the Supreme Court uses the norm of prospective overruling, and it says it is overruled from the prospective. A similar situation of a post-constitutional law, the Supreme Court voided a certain provision in the IT Act due to the vagueness in its nature. It said Section 66 is void because it criminalizes every statement, and any statement could be brought within the purview of criminality. Therefore, it voided it. So this is an example of a post-constitutional law where the Supreme Court brought in these issues. The recent judgment on right to privacy, holding that right to privacy is also part of the fundamental right to life of a person, is also an extension of this doctrine of fundamental rights. Therefore, friends, we see that Article 13 is such a wonderful superlative section that it forms the fulcrum and basis for the control to be placed by the judiciary against unconstitutional laws. Therefore, all threats and injuries against the Constitution, which is originally envisaged by our framers, is tackled there through Article 13. Now, what are these fundamental rights? Many speakers before have brought in what these fundamental rights are, but there is a unique aspect of fundamental rights, which we need to run through for about 2 minutes, because these sort of a fundamental rights is not in existence in any part of the world. So merely for the uniqueness of this fundamental rights, we need to understand what it is. Indian fundamental rights is not a typical cut and paste document of the United Nations Convention on Human Rights, nor is it a cut and paste document of the Universal Declaration of Human Rights adopted by the United Nations Conventions. We are a very special society. We have very special problems. We have many, many challenges. Apart from simply taking these fundamental rights or human rights from other countries or from other conventions, we have also set apart certain articles which addresses historic exploitation, which addresses several social evils, and which also addresses issues pertaining to the best development of human beings. I think by far, if you look at all the constitutions of the world, it is the Indian Constitution which has given the grandest interpretation and the grandest guarantee of fundamental rights anywhere in the world. Glanville Austin says that this is some sort of a bloodless revolution, the Indian Constitution. You don't have to have a revolution with blood. It has catered to the weakest, it has catered to the most exploited, and it is one of the best constitutions in the world. So the historical events, if we had just run through from Article 14 till about Article 31, we find a variety of concepts, a variety of ideas brought into the fundamental rights. Article 14, equality. Article 15, which says there shall be no discrimination on the basis of race, sex, sect, or religion. Article 16, which says no discrimination in the matter of employment with respect to the citizens of India, but gives a provision for reservation for scheduled castes and scheduled tribes. And we also have Article 17, which abolishes untouchability. Look at the historical background of the Indian Constitution. We take a departure from the other conventions. Article 18, which says that which abolishes title, because there were zamindars, there were jagirdars, there were chieftains, there were rajas, there were sub-rajas. So all this had to be abolished. Everybody had to be equalized. So this is a special article for Indian scenario. Then ban against Article 20, Article 19, the liberty of speech, the liberty of association, the liberty, all other freedoms and liberties subject to reasonable restrictions. Article 20, ban against conviction without an offense. It's a constitutional guarantee that a person will not be jailed without a conviction, and he will not be convicted without a trial. That is Article 20. Article 21, life and liberty. We're all aware. Famous cases under Article 21. Article 22, prohibition against arrest and detention. The famous Ram Manohar Lohiya's case, where the famous preventive detention case, where a law was sought to be passed. Whenever a preventive detention is made, a person is asked to give an explanation, and that explanation will be looked into before putting him into detention, making the detention permanent. But one of the states tried to change this law and said, we need not look at this representation. The Supreme Court held that this is ultra vires the Constitution. Then prohibition of employment of children in factories, Article 24. Prohibition of trafficking of human beings, Article 23. Then the most important and the most beautiful aspect of the Indian Constitution, the Indian culture, protecting Indian culture, protecting the cultural values of a particular religion, protecting the cultural values of society. So Article 25 said, freedom of conscience and religion. You have absolute freedom with respect to your conscience and your religion. So this was the cultural dimension of Indian Constitution. It came forward to protect these and it came forward to give guarantees to the citizen that your rights will be protected. In a similar way, freedom in Article 26, freedom in maintaining in institutions of religious and charitable purposes, for religious and charitable purposes. Then Article 29, freedom to conserve any language, script and culture. For example, if I'm born in with the mother tongue of Kannada, another is born with the mother tongue of Tamil, each one of us have a right to protect our specific indigenous script and culture. These are, dear friends, some of the main facets of Article 14, of Part 3 of the Constitution. Apart from this, we have Article 31, 31B, which says some of the laws which are still in violation of fundamental rights, but if they are put into the basket of Schedule 9, that is Article 31B, then they are still valid. Some such laws are the urban land sealing laws, the Inam abolition laws, and the protection given to scheduled castes and scheduled tribes with respect to transfer of property laws. All these laws, due to the historical exploitation, were brought into a Schedule 9 basket under the Constitution, and special protection was granted merely because they could not be tested under the Fundamental Rights Chapter, and if they were tested, they were to be unconstitutional. So they were given special protection. So if you look at the beauty of our Indian Constitution, you find that we address historical curses, historical evils, we give modern rights, and this is in alignment with the broad Indian culture. This is the beauty of our Indian Constitution. Therefore, friends, under all these specific articles, a law that is passed by any of the legislatures has to be tested, and it has to pass all these various tests laid down by all these various articles. Each of these articles have specific tests, and those tests have been brought out in earlier lectures. So we need not go into that, because this is not a elaboration of fundamental rights. But each of these tests forms a ground on the basis of which it can be checked. We have some interesting cases under this provision. Ram Manohar Loya was a very big activist. If he started his speeches, there were millions of people who used to follow him, like Anna Hazare. So the state of MP thought of an idea to curb or check this man. What it did, it passed an order. It passed a law that said, whoever intentionally makes people, urges people through visible representation or otherwise, urges people not to pay taxes or not to pay debts to the government, they will be punished, and they will land in jails. This law was challenged before the Supreme Court. Supreme Court in Ram Manohar Loya versus State of MP year 1960 SC 633 said, this ban not to say anything means a total ban which affects the freedom of speech of the individual, and therefore the law is void. This was one of the most beautiful illustrations. There was also a Kameshwar Prasad's case. Kameshwar Prasad's case was against government employees. A law was passed by the government saying no government servant must go and boycott or go into any agitation, do any agitation against the government regarding its conditions of service. The Supreme Court tested that law. The Supreme Court said this was a total ban. Even a peaceful demonstration, if a peaceful demonstration is also banned for a government servant, then he has no right to, this is a invasion of his freedom of expression. And therefore, they set aside this provision. Therefore, friends, what we see now is that Supreme Court also is progressively moving in different directions. Supreme Court has brought in some very dynamic interpretation in modern times. If ever there is any court throughout the world, the French courts, the English courts, and the American courts, any court that has evolved comparatively faster to adjust to modern times and to adjust to modern technology, one of the foremost among them is the Supreme Court of India. We find this evolution. The Supreme Court is very open to concepts from various other countries, but it also is very unique and creative in laying down its own concepts and tests in order to bring out the best law possible for humanity. And we find that there is a progressive thinking in Supreme Court. We find that it is adjusting to social and economic changes very fast, like you saw the privacy judgment. And it is ready to embrace a new vision. And this is the greatness. And its judicial activism and dynamic evolution is by far the best in the world. And this is where we see that it surpasses other countries. Justice Jackson, he was one of the judges who conducted the Nuremberg trials. Though he was a US sitting Supreme Court judge, he was appointed specifically as the chief prosecutor to prosecute the Nazis in Germany in Nuremberg. So Justice Jackson says, very beautifully he puts it, he says, the Constitution has gone through several cycles of interpretation over generations, each of which is related to the political and economic condition of the period. It is so essential that we align the Constitution, we coordinate it with the specific political and economic condition of the period. Instead of talking or instead of laying down the law in very archaic or academic terms. Justice Cardozo says, the generality of the word liberty, which was laid down in 1870s in the Constitution of America, the generality of that word liberty has successively been interpreted over generations. And even now, it is finding new interpretations, the word liberty. Today, the word liberty is applied to technology law. It is applied to WhatsApp conversations. It is applied to social media, and it takes on a different color. So this is the way, friends, that we have all these various interpretations. The most, of course, the most difficult one for the Supreme Court was the Shabarimala one. It was a conflict between freedom of expression under Article 19 and the right to do puja of a woman under Article 25, and the right to conserve the religion and culture of Hindus, which had a certain way, which had prescribed a certain way for Sabarimala temple. So there are chances that while deciding while deciding the status of certain things, you will have conflict within the fundamental right itself, and this has to be decided. The next that we see is there's one interesting area which we need to which we should not forget in this area of law. The uniqueness of this constitution is that suppose we are fighting a suit, and in the suit the question of unconstitutionality arises. Somebody says that, look here, we have to test this law. As a defendant, one can say that unless the unconstitutionality is decided in the suit cannot proceed. A similar such case came up in long ago in one of the challenges, and that was in Ganga Pratap versus Allahabad, 1958 Supreme Court 293 AIR, and where it pertained to zamindari debt reduction. The question was whether the debt reduction applied in that case or not, or whether the suit was maintainable for that debt. The defendant filed an application, and he said the suit cannot be decided until the constitutionality is decided. The interesting issue was whether a defendant in a suit, without challenging the law, without seeking its interpretation in the High Court, can raise this question. And for this, the defendant raised Article 228 and Section 113 of the CPC, Article 228 of the Constitution and Section 113 of the CPC, and said, please refer it to the High Court. The trial court denied, the High Court denied, it went to the Supreme Court. Supreme Court said, yes, he is right. This matter, first issue to be decided is whether the statute is constitutional. A defendant is entitled to raise it, and therefore it has to go to the High Court, and High Court has to decide it. In similar questions were answered. If you can just read through Article 228, Section 113 CPC and Order 46 CPC, this is written there. This is borne out there. In Kochuni versus State of Madras, 4 judges said one can give a declaratory relief like in a suit, in a writ proceeding. And this was unanimous. This was a 4-judge bench judgment. And it also said while deciding fundamental rights, courts can go into disputed questions of fact. So therefore, friends, this is the law pertaining to the fundamental rights. And there is a very high duty cast upon the Supreme Court and High Courts to determine constitutionality. Many a time they say that, well, constitutionality, we'll look into it later. No, the constitutionality has to be determined, and this is of the highest priority under the Constitution. Therefore, friends, if we look at this one part, that is the violation of fundamental rights, it is very essential that all laws pass the test of fundamental rights. There have been several attempts. We have, as students of law, we have to know that there have been several attempts to prevent the courts from testing the law. One such attempt happened in Indira Gandhi versus Rajnarayan's case. In Indira Gandhi versus Rajnarayan's case, the then Prime Minister declared that no election of a Prime Minister or a Speaker of the country can be subject to electoral laws. So therefore, she declared by a constitutional amendment that you cannot test those laws at all. In Indira Gandhi versus Rajnarayan, the Supreme Court struck down that constitutional amendment and said the amendment is invalid. The Prime Minister's election to the House, and the Speaker's election to the House are equally susceptible for questioning. In Kyoto Holoham, this is the defection cases, and there have been a long line of defection cases. One of the ground under which Schedule 7 was challenged, Para 7 of the 10th schedule was challenged, was that it makes the orders of the Speaker final. So therefore, no court can test it. And there again, there was an attempt to prevent the judiciary from scrutinizing the acts of the Speaker. They said the Speaker's entire orders are immune from testing by the courts. The court struck down this position and said that judicial review is a basic structure, basic feature of the Constitution. Therefore, it can be looked into. We have the instance of Karnataka itself in S.R. Bommai's case. S.R. Bommai's government was toppled by the central government. It was thrown out by a presidential proclamation under 356. When it was thrown out, at that point of time, S.R. Bommai, the then chief minister, filed a case before the Supreme Court. It could not be decided within the next term. But nevertheless, the Supreme Court went into exhaustively the question of whether the president's order issuing the declaration of presidential rule is subject to a test like a normal order. And the Supreme Court said, though he is a high functionality president, it may not be under the normal principles, but still the Supreme Court has a right to test this order and to set aside it if it is found violative of the Constitution. Therefore, friends, these are the grounds on which the laws are challenged. I also refer to you abdication principle, where the legislature self-effaces itself and says, this law, we will not pass this law, we will hand over this law to the executive to pass it. One beautiful judgment on this is Queen versus Burra, 1871 case, which went up to the Privy Council. In the areas of Bundelkhand and hilly areas of UP, the then British government passed a law. The British government said that the local state can decide, the legislature said, central legislature said, British Parliament said, local states can decide when to apply this law or when not to apply this law. This was challenged as abdicating the entire responsibility to the executive. And therefore, there was effacement of the legislative power. The legislature had abdicated itself. At that point of time, they said, no, there is no such abdication because they will have to decide it on the local factors. This was a pre-independence judgment. Post-independence, there is a beautiful judgment of Pondicherry legislature simply adopting the Madras Sales Tax Act. The Supreme Court said this is void. You cannot adopt the Madras Sales Tax Act blindly. So this is another area of challenge to the Constitution. The last area, perhaps the last but one area, is the fields of legislation. I have already brought out these fields of legislation to you. One of the tests that is applied here is the pith and substance rule. They will look into the pith and substance of the legislation and then decide whether the legislation is in which list, and then say as to whether the law is valid or not. One of the best judgments in this is Sundaram Iyer's case. And Sundaram Iyer's case brings out a beautiful concept. It says, when you make a law, first you analyze whether the law is in conflict with any other law. If it is not in conflict, then the law passes the muster. But if the law is in conflict, then you take the test to the second level. That is the second test that is to be applied. You examine the pith and substance of the legislation. And when you examine the pith and substance of the legislation, you find out, that is the pith and substance test. You analyze as to whether under which entry this specific law comes, whether it comes under the central list or the state list. And after properly assigning its list of entry, after looking into the overall law, its objects and its effect, then you finally decide as to whether it properly falls within the jurisdiction of that legislature which passed the law or not. If it does not fall within the jurisdiction of that legislature, the law will be declared void. But before declaring that law to be void, there is a third test, that is the ancillary test. The ancillary test says, suppose I made a law on land, the state under which is a state entry, but incidentally I have also made a law concerning some mineral in the land. Then there is a trenching or invasion into another legislative sphere. But if it is essential to regulate some part of mineral in order to effectively control land, then they say the ancillary powers are always there in order to make this law. So these are the various areas, my friends. I would like to share with you in last 5 minutes before I end. I'd like to share with you some of the lawyers' tips that have been given to us by some great seniors. I think as lawyers, we need to always share this information so that that wealth of knowledge which they acquired is always shared amidst us and is passed on from lawyer to lawyer and can be used by everyone. Many lawyers say that one of the most important aspects for our profession, three important aspects of our profession, is language of law, language of English, which is very essential for law. Second, the knowledge of law. And third is what are the skills in law? Language, it is very easy to build language as we talk and speak. But if I can suggest a method, there is what is called this English thesaurus. If we look at that thesaurus, and if we can train ourselves with about 1,000 words or 500 words, I think that is more than sufficient. Lord Denning used to say 300 words are enough for lawyers. To simply train through 300 words, each word will have about 5 meanings. So a thesaurus is very essential to build the rigorous capacity in the law. Second is the knowledge of law. Of course, along with this thesaurus, we need to read, because without reading English articles, our capacity to really build our thoughts, we have a very huge potential in our minds to build our thought capabilities, and we need to apply ourselves. One suggestion that I can give you is, in all the newspapers every day, particularly the English and Kannada newspapers, both of them are very good. You get the articles on the central page on all issues concerning the nation. And it is very essential in order to get that control over English, one, and to get that control over a range of thoughts, control over your thoughts, and to deliver very well in the courts. You need to just read 2 or 3 articles a day. Perhaps if you could do 5, it's great. If you could read 5 articles a day, they're so very interesting about various opinions and trends. And if you could read that and develop about 300 word language, knowledge of about 300 to 500 words in thesaurus, you will have a very good grip over English and thoughts. So far as knowledge is concerned of law, we initially, when we enter the profession, that we think we need to read all these books, then I'll become the greatest lawyer, very good lawyer. No, you need to select some specific areas of law which tilt your capacities, which really build your potential. And those areas of law are just about 5 or 6 subjects, friends. If you're thorough with the fundamentals there, you could be one of the greatest lawyers. And they are: 1, Constitution, basic elements of the Constitution. The entire Constitution need not be read. You need to know Part 3. You need to know High Court jurisdiction, Supreme Court and High Court jurisdiction, 226. You need to know 300A, property. You need to know 303 to 9, with respect to recruitment under states. Just important areas. If you are thorough, then you will have amazing exposure under the Constitution. Second is interpretation of statutes. It is so very essential that interpretation of statutes, we are thorough with all the principles of interpretation of statutes. One of the best books that I can suggest is Interpretation of Statute by Stephen Bennion. He wrote his last volume, Stephen Bennion. He wrote his last volume at the age of 89 years, the last edition. And he says, this is a book which is to be used. He has drawn in principles from about 5 centuries of law. And he says, this is a book which is to be used from the earliest student of law to the Lord Chief Justice General. For everyone, this book will be a guide. So therefore, that is also a very important aspect in law. Interpretation of statutes. Administrative law. The whole of High Court work is based on administrative law. It may fall under several acts. It may be under appeals or original jurisdiction of the High Court under 226. But you need to be thorough with administrative law and the principles of administrative law. One of the best books in India for administrative law is Administrative Law by M.P. Singh. It is in 2 volumes and it has captured hundreds and thousands of case laws on the subject. If you could go through the basic principles, that is sufficient. The other 2 important areas, those who are in non-criminal side, is evidence and CPC. There are many civil experts in our profession, such great titans, such great giants in civil law, and they could turn a case in any way. Such was their greatness. I've seen Justice Vishweshwara practicing. Justice, I'm sorry, not Justice, lawyer, senior advocate Vishweshwara practicing, many other senior advocates. We grew under them. They used to teach us. In one beautiful instance, we were doing the Nandi infrastructure case with Justice Vishweshwara. I'm sorry, the senior counsel Vishweshwara. I was assisting him. And all the state engineers were there. We had to decide how much of land is required to acquire for a 40-kilometer ring road. He asked the engineers, they did not know. The greatness of that man was so amazing. He took the table books. He told his junior, hey, table books at combine, calculator at combine. How much of land is required to acquire 40 acres of ring road, a double highway ring road? He said, he asked the engineers, what is the width of the road? He calculated it acre-wise and told the court that there was an excess of 2,000 acres. This is the manner, friends, these great senior advocates have donned this profession. So therefore, evidence and CPC is very, very essential. And decisional law, if you can just run through some decisions every day on constitution, on any of these subjects, you will be far ahead in your profession. The last before I end, the last suggestion that I can give you is, when you read a judgment, this is very important, how our brain builds its thought potential. When you read a judgment, when you see the conclusion by the Supreme Court or the High Court, you ask yourself, if I was a lawyer facing this, how can I counter this? This may be an opinion of the Supreme Court. It may be a final judgment. But how do I counter this? When you counter it regularly, you find that your thought capacity and your potential in law really explodes. So if you look at, don't say that this judgment is final. No, start countering it in your mind. You say, I can counter it under the principle of natural justice. I can counter it under the principle of statutes. The statute says this. I can interpret the statute in a different way and I can counter it. I can also counter it on the principle of humanity. What is justice? So you need to build on your faculties. When you open up these options in your mind and counter it in your mind, you find that there is a tremendous change in your arguments before the court. Therefore, friends, I really thank you for this great opportunity. Justice Rohinton Nariman, who is now the judge of the Supreme Court, I once asked him when I was a student. He was a brilliant lawyer. He used to take about only 5 cases for admission day, charge about 4 lakhs per case. Monday and Friday were the admission day. Justice Rohinton, I asked his wife, there was a event in Mr. Sanghi's house, another senior counsel. So I asked his wife, how did he become such a brilliant lawyer? So she said, look here, what he used to do, he joined as a young lawyer with Venugopal, who is now the Attorney General of India. He joined as a young lawyer there. When he joined as a young lawyer with Venugopal, he used to have 16 admission matters per day. Rohinton used to read all the 16 matters till 4 in the morning and go next day and sit beside Venugopal in every matter and he used to understand how he argues. And after doing that repeatedly, all the 16 matters he used to read, he became a brilliant lawyer. The entire instantaneous talaq case is his judgment. Therefore, friends, this is how we need to build on our law. We are one of the most beautiful professions. I thank you all for giving this opportunity. Our Advocates Association is one of the most premier institutions, and we wish it the greatest in the future and greatest to all of you. Thank you.
Thank you, sir, for a stupendous presentation. Can we now move on to the Q&A session, sir?
Yes, yes.
Can we have the first online question, please? Can we have the first online question, please?
Hello, Vivek Reddy. How are you?
Yes, yes, sir.
This is Satyan Gupta.
Yes, sir. Namaste, namaste.
Namaste, namaste. Wonderful.
Thank you, thank you.
I had an opportunity to hear you.
Thank you, sir. Thank you. Your blessings.
As a spokesperson of a party, now we are seeing you as a learned speaker.
Thank you, sir. Thank you.
Mr. Vivek, you have brought out one point, that is with regard to Mr. G.S. Vishweshwara. I think many people may not know that he was the principal munsif in our civil court complex.
Wonderful, sir. Yes,
Wonderful.
yes, yes,
Okay,
yes.
I had an occasion to
Yes.
practice with him also. Okay.
Oh, really great, sir.
Yes.
He was really a doyen.
Yes, he retired in 70. He took the voluntary retirement in 1978.
Yes.
Then he started his own independent practice. He had a fight with the former Chief Justice of our High Court, G.K. Govinda Bhatt. Then, therefore, he resigned from the job, and he has practiced his own independent practice in the High Court.
Wonderful.
Okay. Then, sir, you are brought out wonderful points with regard to the Constitution, and you are referred that basic features, basic structure. What is the difference between a basic feature and a basic structure
Yes.
of the Constitution?
Yes. This actually the basic feature test of the Constitution, which was evolved in Keshavananda Bharati, sir. And that was with regard to a situation where the courts were asked to answer what is the amending power of the Constitution. The amending power is under Article 368. One big question that came up before, very challenging issue which came up before the court in Keshavananda Bharati was, suppose the Constitution is amended, then is the amendment subject to a challenge like Article 13? Can it be said that the amendment can be challenged as if it is a law under Article 13, or should the amendment be challenged as a separate constitutional law? And while answering this question, the Supreme Court said that a constitutional amendment is not a law under 13, not like any other statute law under 13 passed by a legislature. This is a separate law, a constitutional law, a constitutional amendment. And though the constitutional amendment may be there, it must still pass the basic features, basic structure test. The basic structure test was not fully elaborated in Keshavananda Bharati, but they said that some of the features are that it is a democratic republic, that it is a secular nation, that it is a nation where elections are conducted, that it has fundamental rights. So these democratic principles, fundamental rights, these were the issues that were basically identified as basic structure. When we came to S.R. Bommai, one question was whether judicial review, the right to challenge an act, administrative act, is a basic feature, or the right to go to courts is a basic feature, or whether the court's power of judicial review was a basic feature. And in S.R. Bommai, they said that you may claim that it is a presidential order of taking over the government, imposing presidential rule, but still the basic feature of the Constitution is that it has to be tested, it can be tested. Recently, the emerging dimensions of basic structure test are really expanding. Recently, in I.R. Silo's case, the Supreme Court held there is no longer the concept of Schedule 9. The Schedule 9 was where they put the basket of laws which could not be challenged under fundamental rights. But Supreme Court said from now, there's no longer this concept, because even that has to pass the basic test, that is fundamental rights. You cannot have a Schedule 9 basket of laws beyond the fundamental rights or violating the fundamental rights. So we are looking at the basic structure, dimensions and features of basic structure are being interpreted are being evolved over time. But basically what we have till now is judicial review, democratic principle of government, a socialist democratic form of government. These are the basic features.
Thank you, Vivek.
Thank you, sir. Thank you.
Wonderful, wonderful. How is your dad?
Daddy is doing good, sir.
Wonderful. Please convey me regards to him.
Thank
we have worked
you,
together as a president and secretary.
Yes, sir. Those are immemorable days. I was a little boy then.
Yes. I was watching you as a little boy. You have become a very important person now.
Thank you, sir.
Thank
Your
you.
blessings. Your
Wonderful.
blessings.
Wonderful, Vivek. Okay.
Thank you, sir. Your blessings.
Thank you, sir. We have Professor Sudesh who has a question. Sir, I have unmuted you. You may proceed with your question.
Yeah. Good evening, Vivek.
Good evening, Professor. Good evening.
Wonderful listening to you on some aspects of Constitution. Now, continuing with the same question and same answer that you give, can we equate constitutional morality with basic feature? Number one.
Yes.
Number two, if constitutional morality is applicable in the decisions that the Supreme Court makes, can we extend constitutional morality also lawmaking by the legislature, including ordinance? Yeah.
Yes. a very, very challenging question. Actually, the sort of theory of lawmaking that we have in India, each country has a different theory of lawmaking. The theory of lawmaking that we have in India, or the presumptions regarding lawmaking in India, is that one is we don't go into the wisdom of the lawmaking in India, in England also, and in other countries also. We cannot question the wisdom of the lawmaker or the wisdom of the legislature. Of course, we can question it on the anvil of 14, but once it passes the muster of 14, if there is still residual immorality left, then there is no way that we can say that that immorality can be set right. Because if it passes the muster of Article 14, the fundamental rights, then the law is valid. Of course, we see such instances. For example, in Indira Gandhi versus Raj Narayan, the election of the Prime Minister was set aside without any political implication. I'm not referring to any political party at all. I'm taking it can happen anywhere with any party. That's a different issue. All that I'm saying is a Prime Minister's election was set aside, but the Prime Minister had was in control of a brute majority. And the Prime Minister said, I will make this law saying my election cannot be looked into by any court or looked into by any legislation. So they passed a constitutional amendment at that stage. In such situations, it is wholly immoral. And the court could immediately intervene because it abrogated fundamental rights. But there are some instances where morality cannot be attacked. It is only through fundamental rights that this morality can be attacked, constitutional morality. And that is why in Keshavananda Bharati, they said, sometimes the Constitution speaks by its silence. We need to interpret the Constitution through its silence. And we will have to look into it.
Thank you, sir. Mr. Bharat Srinivasa Rao.
Thank you. Thank you. I appreciate your answer, Vivek. Thank you.
Thank you, sir. Thank you, sir.
Mr. Bharat Srinivasa Rao, I have unmuted you. You may quickly pose your question.
Hello, sir. How are you, sir?
Fine, thank you, Bharat. Fine, thank you. Fine, thank you.
Sir, my question is, in the recent, there was a judgment about the National Judicial Appointment Commission.
Yes.
Hello?
Yes, Bharat. Listening.
Yeah, sir.
NJSC.
NJSC, where the Supreme Court struck on it. Right.
Yes.
So now, since it's a principle of natural justice that he cannot be judged for his own cause, it is the cause of the Supreme Court appointment only. Then how can they went ahead for that?
Well, I think this is a very debated question. The point is this, that when selection of judges is placed at the hands of the executive, there is every chance of politicization. When executive members of the government sit along with the Chief Justice as one of the members, there is every chance that the executive may choose whomever they want. This is one aspect. The other aspect, the other extreme that we have in India is a collegium system, where the collegium decides, because in all aspects of judicial function, it is the judiciary which has to decide, and that is embedded in the principle of judicial independence. So between these two extremes, we have one situation where an institution can get politicized, and one system which is not wholly perfect, which has a lot of lacunas. So an option that was NJSC judgment basically said that this is an invasion of judicial independence, because another body, an executive body with executive functionaries, are sitting here to decide the making of judges. I think in an American system, it's totally different. They will call the judges in legislative panels, committees, and they will grill the judges. They will take their entire history out. But India does not have that amount of, time to bring out the judges and fight against them. I mean, raise their issues before the legislative panels. Even that becomes politicized. So in the circumstances, we feel that what is more important is independence of the judiciary, and that's why the judgment has come about.
Okay. Thank you, sir.
Thank you, brother.
Thank you, sir. One last question. Will Dr. Nagaratna has a question. We'll take up this question. Yes, ma'am, I have unmuted you.
Yeah. Thank you. Hi, Vivek. Am I
Yes, yes.
that was a wonderful speech, especially between the jurisprudential analysis along with the law framework. Thank you so much. I just have
Thank
two questions, which has always perplexed my mind as an academician. So you did mention that the law in India provides for a very major role to be played by the judiciary, like an umpire. But of recently, we've been seeing over no, reaching power of the judiciary itself. The recent judgments have been, sometimes they themselves are unconstitutional. So, what do you think? I know judicial review can be one of the legal remedy, but your opinion on this? The second one is most of the laws that gets enacted these days are also, beyond the constitutional framework and quest to make a wider law. So we end up compromising with the constitutional validity. So that can be seen even in the cyber law, section 66A, or most of the other laws, and even the upcoming new enactments. So your opinion on this? So do you think we need to keep in mind this constitutional framework even before enacting law, apart from anyways having judicial review as a remedy later? How do you think lawmaking process can get more revised from this perspective?
Yes, I think, thank you, Dr. Nagaratna, for your question. The first part of your question was very interesting. Sometimes Supreme Court itself will fall in the wrong line of, I wouldn't say that, but sometimes its opinions are there for future Supreme Court to overrule it. This has happened in Golaknath and Keshavanand Bharati. Golaknath's case was formulated with certain principles that was overruled by Keshavanand Bharati. So if you look at Justice Cardozo or Justice Jackson says, a dissenting opinion is always an opinion that will stand as a reminder for some future batch of judges to correct their views made earlier. It will stand as in memorial that, look here, this is something that you have left unaddressed. These similar situations were seen when Lord Denning used to pass judgments, House of Lords used to overrule. And later House of Lords came into the views of Lord Denning. In a similar fashion, we find several judgments of the Supreme Court taking diverse views, but when it goes to larger benches, the earlier ratios are overruled. So we have to wait. In our system, an unhappy situation is, I understand what you say, an unhappy situation is that all judgments are not perfect. They're all crafted by human beings. Judges themselves are human beings. And many of the judges take their decisions on the basis of the material available and the situation, that social situation that exists today. So a different social situation or a context may bring about a different judgment in the future. This is number one. The second is about the laws which are passed. I recollect a very interesting example. In England, there was a law, very old English law, sometime about 13th or 14th century. It said that no person shall scale the wall of the town. And if he scales the wall of the town, a town in a gode mein lattu, he will be prosecuted and put to jail. But what happened? The real impact of the law was that one day the enemy had taken siege of that city. And one of the persons was coming down after trying to attack the enemy, after trying to protect the city's wall from the enemy. So the question was, do you apply the law literally and blindly to him? I think today we have reached a situation where lawmaking is a science, and the draftsman must be very precise. There is no chance for making errors, and we should ensure that the correct connotation of the object of the statute and the sort of mischief the legislature wants to remedy must be considered. And of course, it has to be brought within the Constitution, and it has to, the lawmakers must ensure that it will pass future challenges. That is also very important. So therefore, Doctor, I hope I'm able to answer your question.
Thank you, sir. We have one last question offline. Mr. Shrikanteshwar advocate has this question. In a court of law, where there is a conflict between the constitutional right and the aspect of truth to be adjudicated as against the cover of law of presumptions, which aspect shall be upheld by the court?
Well, I think this is Dr. Sudesh's morality question. And it's the same question of morality. Many a time we know as lawyers that the criminal we defend is guilty, but he gets an acquittal based on probabilities, based on very weak evidence, or based on technicalities. I think when we look at all this in a system, we should ensure that, for the system to survive, we must ensure that the law and order establishment is more robust and strong. It ensures that it brings home the convictions. It makes it difficult for lawyers to get acquittals. That's when the profession becomes even more challenging. So we need to move in those directions. Unfortunately, the police system and the criminal law enforcement machinery system is very weak and has remained weak for lots of years. But coming back to your question, many a time, untruth passes for constitutionality. It happens. And I think that perfect system which Socrates said, what is the perfect system that we are trying to bring about? For Socrates did not recommend democracy, did not recommend lawmaking by democratically elected people. But what is the perfect system that we are looking at? Well, that perfect system will come when everybody in society would follow those values of perfection, which is very difficult, but that is where we have to head to as a society of people.
Thank you, sir. Now we have reached the fag end of this session. Before we log off, I would like to extend my heartfelt thanks to you, sir, on behalf of Advocates Association Bengaluru for a very informative and academically enriching session. Thank you, sir. Thank you so much.
I also like to thank the President for giving me an opportunity, and the office bearers, Secretary, and all others for giving me an opportunity. Thank you very much.
Thank you, sir. With your permission, now we'll be logging off today's webinar.